Hello, everyone, and welcome to the Dragons, Gazelles, and Unicorns podcast and webinar. I'm Rosemary Truman, founder and CEO of the Center for Advancing Innovation and Ignite Social Impact. I'm here to welcome Pete Thurlow. He's a prodigy, prolific IP attorney, family office organizer, and also part of the DARPA team. He works a lot in the life sciences field and is an all-around maestro to guide entrepreneurs and investors in paths to trailblazer companies. Pete is acutely aware of how to make all stakeholders in their particular ecosystems triumph by ensuring all parties understand the dynamics of what is involved to drive success. And believe me, it is true. He has helped many of our startups. It's quite incredible that the amount of wisdom that comes out of him, way beyond IP, but really to help entrepreneurs grow. Pete creates exceptional IP strategies and has architected and led an elite team to make his clients successful. Pete is also very kind and generous, as well as all these other remarkable attributes. So I want to thank you very much, Pete, for your valuable time. And could you say anything else about yourself?
No, I think you'd covered it quite well. And I want to start by thanking Rosemary. She's been a friend of many years, and all the amazing things that she does for startups and the incubator community, the innovation area. It's a pleasure to work with her, but it's even more of a pleasure to have her, to call her a dear friend of mine. So it's nice to do this podcast today, and excited to help in any way I can.
Thank you, Pete. So could you give the audience a little bit of background about how you came to where you are currently in your journey?
Sure. Happy to do so. I'll give you the relatively short version. I've been practicing patent law for almost 25 years. Grew up in Brooklyn, New York, and worked in New York for many years. I have a mechanical engineering background. For those of you that may be familiar with intellectual property and patent law, you actually need a technical background to practice patent law. So after I went to law school at night and graduated from law school, I was working at the electric utility in New York, and then I took the patent bar exam, and I got my registration number. The patent area is one of the few areas of law where you have to take a separate bar exam to get your registration number. So back in the late 90s, I was first introduced to patent law with some engineers I was working with. And then back in 2000, I switched from a big company I was working with in New York City to private practice. I went to what we call is a patent boutique. And I worked there for 5 years just doing patent prosecution. And then again, the short version, from there, I went to a very large international law firm for 11 years. And then for the last 8 years, I've been at this firm called Polsinelli, a good Italian name. We have more than 1,000 attorneys and 23 US only offices. And we're a general practice law firm. I'm based in New York City on 40th and 3rd. The main office is in Kansas City. And we have, of the 1,000 attorneys, we have more than 160 professionals just in the intellectual property patent group. So the summary of that is, you need the engineering background. So it's a nice niche to be in with the engineering background and my law degree. And something I've enjoyed working in very much is the patent law area.
So, a lot of people who listen to our podcast are wondering, how do you get to these different steps? So what is kind of the secret sauce to your trajectory? I mean, so I always think that I worked a lot in consulting, so that I always see different people bounce around in different consulting firms. How did you traverse those different firms?
It's a great question. The secret sauce, the trade secret, since this is intellectual property focus for me, is really kind of goes back to my roots and as coming from the big family, youngest of 9, from a family in Brooklyn, where we were just kind of taught to be just really active. So when I went to the patent boutique up in Midtown Manhattan all the way back in the year 2000, one of the first things I did is I walked down the hall to a very nice senior partner, and I told him I want to do more than just kind of being an attorney. I want to get involved. And he recommended I get involved in this intellectual property law association called New York Intellectual Property Law Association. So I got involved there as a young attorney, and I just met a tremendous amount of people. So through that, I met just a bunch of people that I'm very close with at the U.S. Patent Office. And then I always believe one door opens up another door. So when I met the people at the Patent Office, I would started attending meetings at the Patent Office. I would report back to the Bar Association and my colleagues at the law firms I work with on developments in patent law. And I was always amazed at how one step led to another, where all of a sudden I became the representative of the Bar Association at the Patent Office. And then years later, the Patent Office asked me to join a 9-member advisory committee called PPAC, Patent Public Advisory Committee, where for 6 years, 2 3-year terms, I served as an outside advisor to the Patent Office. I worked closely with the director and the senior management team at the Patent Office, and just met a lot of people at the Patent Office and then in industry working on important intellectual property issues. So a lot of hustle, Brooklyn hustle, as I call it, but just a lot of meeting of really good people that one opportunity led to another opportunity.
And could you tell, I love the Brooklyn hustle.
Yeah.
So for the people who are listening to this podcast, could you describe what the Patent Public Advisory Committee is? If I took it down.
Yeah, so a lot of government agencies, they want input from practitioners. So the patent process is somewhat of a challenging, arcane system for anybody outside, especially independent inventors and people in the business community. To the extent they hear about patents, you have a lot of rolling the eyes, and there's a misunderstanding or not enough understanding of the patent system. But it actually goes back to Article 1, Section 8 of our Constitution, where they have intellectual property rights in our Constitution. So what the government does, the U.S. Patent Office has maybe 12 or 13,000 full-time employees. 8,500 roughly or so are just U.S. patent examiners. So we take the experiences from our private practice outside of the Patent Office, and we would relate them to we would provide that information to the Patent Office, whether it be about the quality of patents overall, about the timing it would take to start and get a patent, about some intellectual or international intellectual property issues. There was a big deal years ago and today with intellectual property theft from certain foreign countries that we work with on the Patent Office and also different agencies. And we would advise the Patent Office and this Patent Public Advisory Committee about things that we saw in the day-to-day business operations. Something I enjoyed very much. Each of the 9 members were senior members of the business community that have a lot of IP experience. And each member was appointed by the U.S. Secretary of Commerce. And it was something that we would meet quarterly, and we would prepare reports that would go to Congress, the Patent Office, the White House, and many other groups on what we thought was the state of the patent system and ways to improve it. If I can give you one example of something that came out of that, there's now something that we call Track 1, Expedited Review. That's something we worked on years ago at the Patent Office to expedite the review of patent applications. Traditionally, it takes 18 to 24 months for a patent application to get reviewed. When I worked with the Bar Association and with PPAC, we put this expedited review Track 1 program in place that by paying additional fee, independent inventors and others would be able to go to the front of the line to get a patent application reviewed sooner rather than later. There's many benefits of doing that. some related to raising capital at the patent office. But from the relationship we had and the work we did with the patent office, the Track One program is something that we worked on very closely when I was at the Bar Association and also as a member of PPAC. So it's just an advisory committee where you try to give them feedback to help the patent office do better.
Mm-hmm. So the Track One program is for expedited FDA review.
It's not. I'm sorry to interrupt you. It's more for the patent office. The FDA isn't. You know, I chair the med device group at Polsinelli, but that's expedited review at the U.S. Patent Office is Track One.
Yep. And then there's a Track 1, 2. Well, it's a for orphan indications or when you're actually creating your therapeutic or your device or what have you. So I was going to ask.
Yeah.
I was going to ask you about that as well, but I don't want to get down in the weeds there. But so if you get the expedited patent review, do you get an expedited clinical trials review as well?
So the FDA, we have an FDA team at Polsinelli. We work very closely together. The FDA is very critical, and we do work closely with them. I don't want to, I guess, confuse the audience by diving into that. It's better to have more of an FDA attorney on there on a separate podcast. But we work closely with them to make sure that any information given to the FDA is also given to the patent office. That you know, that we work closely with the FDA, that any data that we provide to the FDA, we also provide to the patent office, to what we call is a legal requirement in patent law called enable the aspects of the inventions. So as we work on prototype, as we work on testing for therapeutics and med devices, we're always working with the FDA and we're working with the patent office to make sure we provide them with the best information possible. So we can get expedited review in many situations, and we're always working with FDA counsel to make that happen.
And so we dive into some of your medical device expertise, probably coming from your mechanical engineering background, but also, you know, obviously I think a broad scope of knowledge in that area. But I know that you also work in therapeutics and diagnostics as well, and can provide lots of different kinds of advice for entrepreneurs in that area and startups, as well as even companies that are trying to figure out their patent strategy. So I just wanted to dive in to see if you had any particular advice for organizations that are working on in the life sciences arena.
Sure. So again, I mentioned I've been practicing for 25 years and with a team of more than 160 professionals. I have a lot of deal flow, and I see a lot of different subject matter. So specifically in the med device, there's a lot of work that was done on the big deals for stent-related technology, cardiovascular technology. We also work very closely with a number of orthopedic surgeons and other big companies in the med device space. When you look at advice as far as what to give to startups and even big companies on the application side, we try to use a sports analogy where you look at things from an offensive standpoint. So from an offensive standpoint, that's really your own or your company's intellectual property. Going back to March 16, 2013, the U.S. patent system is what we call a first inventor to file system. So in a very inexpensive way, we try to file patent applications by using what is commonly referred to as a provisional patent application. So whether you're a big company, whether you're a startup, whether you're international, domestic, we try to get a provisional patent application on file so that it establishes a date certain of your invention in the patent office. Then that provisional patent application gives you 1 year to follow up with a non-provisional which is more of a full-blown, complete patent application that has a detailed description of the invention, has drawings, and most importantly, it has what we call as claims that lay out the metes and bounds of your invention. So the patent office is what we call a quid pro quo system. You provide a full and enabled disclosure, and in return, you get exclusive rights to the aspects of the invention for a period of 20 years. So on the offensive side, we try to get a patent application on file, normally a provisional, to protect the aspects of the invention. Depending on the size of the company, we also do a defensive analysis, is that we look at what other companies are doing in the space, and that is somewhat by what we call a landscape analysis, and also what we call a freedom to operate analysis. And that is more seeing what competitors in the market space are working on. If you relate to any technology, whether it's stent technology, whether you look at AI technology, which is one of the hottest areas for startups right now, if you look at CRISPR technology, which is very hot, if you look at RNA and DNA technology, all that stuff is very hot. It's important to know what competitors are doing in the marketplace. So we recommend that for both startups, and we recommend it for big companies. And then the decision as far as the next steps really comes down to the budget for both those startups and for the bigger companies, and what we want to do in the United States and internationally.
So Pete, just on the AI front, do you have an opinion about what Biden is doing there? Because how would that affect the patent landscape, for example, and also maybe the offensive side that you mentioned?
Yeah, I think that's a great question. We're still studying the recent administrative order that President Biden just released yesterday. I will tell you, though, I'm familiar with it, and this goes back into what we were discussing, is that I was in the United States military, went to a military school called U.S. Merchant Marine Academy, and for the last 5 or 6 years, I've been working with DARPA. DARPA is an acronym that stands for Defense Advanced Research Projects Administration. In short, they have a $4.3 billion budget, only about 215 employees, and one of the roles is for them to invest money in U.S. companies to protect and commercialize their own intellectual property. In the AI space, we've all been reading lots about it, from Elon Musk and many others, of course, with the chat GPT and what's going on in that space. The AI space is one of these critical areas that we have a technology competition. I don't like to use the word war, but many people do, with a lot of international countries, many of which you all know. So the idea between what the administration is doing now and also on export controls is really to protect certain technologies, AI included, in the United States, so that we can benefit from the advances in that space, and quite frankly, not have what is considered adversaries or those that would use that technology against us, whether it be at a time of war or just commercial development. So I think what President Biden is doing is very effective. I think what he's doing is correct without getting into politics. And the overall scheme is to protect our nation's intellectual property for our own benefit. I'll only add, years ago, maybe 10 years ago, when I worked with the Patent Office, I worked with the House and the Senate on protecting our intellectual property. It's something we continue to do today with President Biden, but we also did it with earlier administrations. We're going to do it with future administrations to protect intellectual property, to protect chip technology. You name the technology, whether it's battery related, whether it's lithium ion, or so on. The idea is to protect what we have. Intellectual property in the United States has been valued at more than $5 trillion. And whether it's AI or, mobility related technology, the idea by the administration and others is to protect it so that we get the benefit of it. And is that helpful?
Yes, very helpful.
Yeah.
I'm very passionate about that topic, about commercializing IP. I mean, actually, the estimate that you came up with about 5 trillion. We did an estimate that was that if we get 6% more inventions out every year, we could make a $1.5 trillion GDP impact on the U.S. economy, and we estimated $3 trillion worth of IP sitting on the shelf. But because every year we in the U.S. spend the most, 140 to 160 billion dollars on just the R&D that goes on in the universities, hospitals, and federal labs. So beyond that, got all the IP that's sitting in the companies. But I think about IBM; they're the largest IP producer in the world, and they have maintained that for many, many years,
Right.
25 years.
Yeah, I think it's a great point with all the work that you do with incubators and universities and the startup system in DC and around the world. I think it's critically important. Pulcinelli, we have a number of significant university clients, but whether it's university or the startups that come out of the incubators, like your incubator, or even hospital systems, the real goal is to protect that intellectual property and commercialize it. More often than not, I get brought in on deals to, excuse me, not just protect the intellectual property, but to work with family offices, to work with companies, strategic partners on commercializing that IP, and to help them with joint ventures, partnership agreements, collaborations, and then to get that money in from family offices to get that capital into companies, whether it's from friends and family, seed stage, Series A, B, C, D, and up, and others, to get those companies and to commercialize the IP. One of the things, just to finish that thought, is we work with the companies to get the capital from, whether it's the National Science Foundation, DARPA, the NIH, but I don't think enough companies look into local cities and states at what they're doing. For example, to give you two examples, one close to home to you, Rosemary. First is in Texas, called CPRIT. There's a $6 billion program for the state to invest in cancer-related startups that come to the state, are in or come to the state of Texas. But Rosemary, you're probably familiar with Tedco, who I met actually at your event at Wharton many months ago. But for companies and businesses in Maryland or moving to Maryland, they have their own investment arm that invests in those companies. So I think as we work with companies like that to get capitals into the company, and we use that money to protect the intellectual property. So it's one big system looking at how we can most help the startups and other companies.
So just for everybody on the podcast, this is an extremely important point. So essentially, Pete is at the pinnacle, the nucleus of connecting capital with startups, and the capital from this wonderful coalition he's built of family offices, but also the university systems he's connected with, and other state and city municipalities. So this is an extremely important point for everybody. And you mentioned CPRIT, which is a foundation. So there's a foundation side as well that he also is involved with. So he's kind of a mastermind at connecting all the different organizations with startups that require capital. But also, I would say that for the startups that I have introduced Pete to, he's been extremely helpful with navigating, as I mentioned at the very beginning, the entrepreneurial ecosystem, or let me call it community, because there's an ecosystem. One word, community is a different word, but he's able to create kind of a set of correct stakeholders around startups to help them advance their technologies and their companies a lot faster than normal. So
yeah, what I'd say on that, and thank you very much, is my expertise is in the IP patent area, but I'm pretty confident everybody that listens to this podcast, at one point or another, there's a need for capital. And there's a great book, if anyone's interested. It's Secrets of Sand Hill Road by this guy, Scott Cooper, from Andreessen Horowitz. And it's just how you raise capital. And I say that because I am IP counsel to 30 or 40 companies, but I'm really outside general counsel, where we look at the whole business itself. As important as intellectual property is, you need to understand the corporate structure. You need to understand the cap table. You need to understand the real workings of the company and who's on the advisory team and the board team. It would be respectfully, we try to, Pulcinella, we try to provide a business perspective to important legal issues. And if you don't know the business, then I don't care how good of an attorney you are, you can't give them sage advice. And sometimes that advice is outside of the intellectual property area. And Rosemary, we could tell the story how we're not just working, me and you, United States, but whether it be countries like Thailand and elsewhere, where there's the same needs: the need for protecting IP, the need for capital, the need to have joint ventures or collaboration agreements with strategic partners. It's the same in the United States as it is internationally.
it's always amazing to me. There's a real desire to move it forward as well, and having the United States involved in helping them do that is quite important, because they're trying to get their intellectual property into the United States, and sometimes it's a mystery for some of the countries, which you're helping to create that bridge.
Yeah, we work with plenty of international companies that are trying to understand the intellectual property system. Intellectual property is, in general, what I'd say is territorial. So I need to get clients' patents in the United States, and then we need to get them in Europe, and then around the world: Australia, India. Certain countries, there's been a lot of challenges with China and so on. But so we really look at the countries and see where we're going to get protection in. But again, it really goes back to the business plan, the budgets, and so on. Certain countries, it's just we don't need to get patent protection in, because the nature of that country, they don't have intellectual property going back to the formation of the country or in their constitution like we do, so like the United States does. So we look at it from an international perspective and where it makes sense to spend the money.
So Pete, makes me think of one of my the companies we've launched, and some of the other companies we were helping as well. One key issue that you just mentioned was they don't realize the importance of IP. So they develop the product, and then it's not protected, and it's first to market, so to speak, but it can't be replicated. So if they don't have patent protection, they may have some challenges. But then also, if they do have patent protection, they may have some challenges too, because they may have to have litigation over a patent.
Right.
So how do you, what strategically do you do about that sort of situation?
It's a great question. There is some, we try to look at it, we look at intellectual property rights as an umbrella of rights, when the more traditional patents, trademarks, copyrights, trade secrets, they all have a different, even within the patent space, you have utility patents and you have design patents. So we look at everything, and we apply what we think is the best approach to the aspects of the inventions. In certain software technologies, we'd be more inclined to use trade secret protection for that. And that's because in certain areas, because of some Supreme Court decisions and just the technology in general, we use trade secret protection. In other areas, say in the life science, med device, and the biotech area, it is very common to use patents, mainly utility patents in the United States, internationally. And based on my career, there's a lot of different reasons. If you take the word exclusive or exclude and substitute that for the word patent, the patent gives you the right to exclude someone from the marketplace for a period of 20 years. So from the pure legal standpoint, if I can go to market and say I have a therapeutic and I can exclude others from the marketplace for a period of 20 years, then it's a very attractive business that investors will build in and helps you grow. So we try to look at everything from that standpoint, and look at what makes sense. And it really varies based on the technology that we're in. Then internationally, we look at, obviously we focus on budgets and where it makes more sense. If you look on the therapeutic side, we're always getting patent protection in India, in Australia, obviously in Europe. Maybe not so on the software side. So yeah, so there's lots of different ways we look at how to protect the intellectual property. And again, we always use a combination of trademarks and trade secret and copyrights and other things to do that. One thing I'll add in the therapeutic side, we'll always get a patent on the composition itself, but on the method of making and other methods, we'll sometimes use trade secret protection for that. And that's because patents are publicly available by those in the United States or those internationally. So we want to disclose enough to get the patent protection we need, but maybe not disclose everything for the methods, and we do a combination of intellectual property. So it gets a little tricky, but it's something that we work on very closely with the inventors and the companies.
So I have a question, because when I was at IBM, they wanted me to patent some of my methodologies and my some tools that we built for strategy consulting. And there was, for example, one was called a business decomposition model, where we decompose the entire business, and then behind each of the components of the business, we had about 1,000 questions. So
okay.
and things of that nature. And then the idea was to create a heat map for where are they spending too much, where are they doing well, where are they not doing well, what doesn't matter. So maybe they're not doing well, but it doesn't matter anyway, because there's no competitive advantage. So I wrote up the patents, and then I was like, oh my gosh, all this data is going to go into the public domain. This is many years ago, 25, 27 years ago. So I told them I don't want to patent it because people will just take it. And the thing is, they had documented every single thing. I mean, there are many. So for the business decomposition models, you have to do it by industry, and you have to tailor it for every company. So I mean, they could take it, but they wouldn't. Also, that was a huge tool. So so we made the due diligence models. We made them all into trade secrets. So my question is, so if you patent something, it's in the public domain, because what I was advised to do by these attorneys at IBM was to write every single piece down. So it's documented, and then to also explain how it cannot, the claims were really hard, because the thing is that they wanted, I had one for oil and gas, I had one for automotive, I had one for, we basically created models for different industries, communications, etc.
Okay.
So that lasts for 20 years. If I published it, and then I was thinking, all they have to do is go in there, and it's pretty non-replicatable because of all the algorithms we created behind it. But because those are the conditions that they looked at. But at the end of the day, we did trade secret. So had I done a patent, that would be 20 years. But trade secrets, do they last forever?
Yeah, so the thing with trade secrets is generally, as long as you keep it secret, the best example of the trade secret is the Coca-Cola formula, but and the thing to understand about trade secrets is it does not give you the right to exclude someone from the marketplace. So whenever you see litigation in the trade secret area, it's misappropriation or theft of trade secrets. And that happens when one employee goes from one company to another. They're bringing themselves physically, but they're also bringing the trade secret and knowledge from one company to another. That's why looking at intellectual property from a holistic standpoint and not just filing a patent application, we look at employment agreements, we look at the intellectual property policy of the companies, we look at everything on a trade secret side, so that even if someone left the company, we want to make sure that the trade secrets and that protected IP is with the company. We have had situations with trade secrets. It does allow for independent inventiveness in the area. So somebody else, you can create a trade secret today, protect it, but a third party, United States or around the world, can come in and independently invent that as well. We have had several situations where companies that initially protect their technology via trade secret, later on, another party, third party, will come in and they will get patents. And because of that first inventor filed the system, they have priority rights to the invention. And even though they came in later and conceived and developed the technology later on, they're able to exclude or at least send cease and desist letters and can sue companies that earlier developed that trade secret technology at another company. So that's why the March 16, 2013 is a very big date in the patent U.S. patent law area, because our patent system changed to first to conceive to first inventor to file, which I worked on with the patent office many years ago. So trade secret and patents are two critical areas, but there is it's very important to know the difference between the two of them. And that's part of what we try to do as we advise clients on their umbrella of rights and the risk associated with each approach in taking that action. So if I could just add one, with respect to what the work that you did at IBM and other things going back even 20 years ago, for those in the patent space or for those in the inventive community, there's a very famous U.S. Supreme Court case going back to 2014 that basically is called the Alice decision, and it deals with what we call Section 101, what's patentable. So one of the critical areas as we start working with clients is looking at the type of technology and the patentability of that. And there's been cases that have gone up to the U.S. Supreme Court since then. The U.S. Patent Office has done a tremendous amount of work in the space. When I was president of the New York Intellectual Property Law Association, we did a lot of work with Congress, the House, the Senate, on trying to figure out what's patentable and tried to change the law. Unfortunately, that was did not go into effect, but it's something, it's a question we have for big companies and startups as far as the technology and what's patentable, that it's important to be aware of this Alice decision, and worked on it very closely with the patent offices and still do. We still track case law in that area.
So Pete, this is an important point, I think, for the people listening here. So what is patentable? Obviously, has to be non-discoverable, non-replicatable. You're the attorney, but how would you describe what is patentable?
We describe it in the biotech area, med device area. That kind of technology is patentable. Once you start going into the software space, or certain tax strategies would not be considered patentable. you have to be a little bit more careful. They don't say what it is, but the Alice decision came out with this very difficult. They said that certain technologies are abstract. So to answer your question, the Patent Office has Section 101 guidelines as far as what they consider is abstract and what they consider is not abstract. So in certain areas, whether it's software technology or in the diagnostics area, certain technology. So we, based on our review of the subject matter of the company that we're working with, we review the case law, we review the guidance provided by the Patent Office, and then we try to advise the client in the area. It's a very difficult thing to do, and we can't promise anything. Even if the Patent Office grants a patent to a company, it does have a presumption of validity under the patent law, but the courts may later determine that because of Section 101, those patents are invalid. So it's a difficult area, something that we continue to grapple with, and there's a lot of concerns with, but it's, it's a difficult question to answer.
So in your opinion then, what are the largest challenges in thinking about intellectual property? What you have.
So it's a good question. It's a hard question. I always have to look at things, depending on the size of your company. We're always looking at budgets, keeping. I'm the law firm partner that wants to keep budgets down initially. How do you protect your IP in a way that especially for early stage companies, we use provisionals. We use not only NDAs, non-disclosure agreements, but we use NDAs and non-circumvention agreements. And there's just a lot of challenges at developing the technology and keeping it confidential. And we're always working on the employment agreements to make sure that the companies own the IP, not the individual attorneys, and they have rights in their employment agreements or obligations to assign their IP rights to a company. So I look at it from many different areas. And, again, I look at the size of the company, I look at budgets, I look at how crowded a certain space is. And then we try to advise the clients based on what we see in the US and internationally. And the work I do at DARPA, all these critical technologies, we're very careful not to have this publicly available. And then obviously we're always worried about getting hacked and other technology being stolen from the companies. It's not just money that these hackers are interested in. They're interested in gaining intellectual property from the universities, from companies, and of course from the US government, so they can get access to this very important technology. And that's something that the FBI is and many others are very focused on. Even the FBI director was on 60 Minutes a few weeks ago talking about their concerns with theft of intellectual property and the importance of protecting our intellectual property.
Mm-hmm. So I know you have to go to another meeting, but is there any last important items that you would like to leave to the kind of the startup and investment community that we have listening today?
For the startup and investment community, early on, I would definitely consider, you have to look at provisionals and you have to protect the intellectual property at the, we say it's never too early to consider what your exit plan is going to be. So whether you're working with a strategic partner such as a Fortune 100 company or international company, the value of the especially the early stage company is really going to be in the technology, and the value of that technology, it's really going to be important as far as how you protect that technology, whether it's via trade secrets, trademarks, US patents, and international patents through the PCT system. So kind of get it right early so it doesn't become a problem later on. From an investor community, I work with family offices as we look at making investments, and we look at several pitch decks a week. We always look for at least 1 or 2 slides in there that tell your story on how you're protecting what is your intellectual property and how you're protecting it. We understand as investors that you may not have money to do patentability reviews, landscape reviews, freedom to operate. But as long as you tell us the story on how you're doing it, and then if we were to invest, whether you would do a landscape or a freedom to operate, the use of proceeds becomes very important. So I think it's very important to get in touch with somebody like Rosemary or others that can, including myself, that can advise you early on in later stage, because there are a lot of nuances to the intellectual property patent system, both in the United States and around the world, that are very important. So happy to help, Rosemary. For anybody that's, I hope they found the podcast helpful, and feel free to reach out through Rosemary, Peter Thurlow at PolsonelliLawFirm.com. I've really enjoyed the discussion.
And thank you very much. Million thanks. You had very valuable insights and wisdom for everybody today. And I wanted to say happy Halloween.
Oh, happy Halloween to all.
And I have a little question for you.
Okay.
Ready? Okay. Yeah. What is the this is off the record, okay? Do you know what the candy is that the Halloween candy that New York likes to have?
I don't know. I had some Reese's peanut butter cups last night, were one of my favorites.
Oh,
but anything chocolate and peanut butter, or just pure chocolate. Trying to eat dark chocolate, but I'm a fan of all types of chocolate.
Yeah, there's a map. I'll send it to you about yeah, it's pretty funny.
Awesome.
I'm in agreement with you. So just to recap, and I know you only have 3 minutes, but recap a few things. Get involved in associations. I mean, that's where you can create your networks. When one door opens, another door. When one door closes, another door opens, and you open a lot of doors through those associations, and that's how Pete went up the ladder quickly. Do the Brooklyn hustle.
Yeah, a lot of Brooklyn. Whether you're a founder or whether you're a young or even experienced attorney, you have to do a certain amount of hustling. And if someone told me 25 years ago when I started practicing patent law that I would be working with family offices, and I'd be working with DARPA, protecting a nation's secrets, and I'd be working with great people like you, Rosemary, I'd say, get out of here, no way. But it is interesting how the career takes you, and if you do the Brooklyn hustle, I think it's just amazing where it can lead you to.
And then make sure you do the offensive position and also the defensive position, potentially.
Exactly.
And when you're looking at capital, don't forget the cities, states, foundations, family offices, of course.
Yep.
These, we could have another podcast on just how you would think about that. Look at your IP umbrella holistically. I think that's a very, very important point. And then strategically speaking, make sure you do a provisional if you're doing a patent, but make sure you're looking at the entire umbrella with someone like Pete. And remember the new laws that came out in 2013 and 2014. So first to conceive versus first to file. So trade secrets don't really protect you. The patents will, to a certain extent, if you get your claims correctly. But if you think about it in the context of the trade secrets and copyrights and trademarks, and then look at the Alice decision of 2014. I mentioned that before, but here's some of the key points that I pulled out. There's more that I wrote down, but hopefully I covered some major ones there.
Yeah, that's great. Well, I have to jump for a Zoom with a startup that's doing some exciting things, and we'll be discussing all the things that we just did. So, Rosemary, thank you very much.